This is Ruffin Hunt with Hunt Law, and today we're going to be discussing the crime of child neglect in the state of Florida. Child neglect is defined in Section 827.03 of the Florida statutes as either 1. A caregiver's willful failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including, but not limited to, food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child. Or 2, a caregiver's failure to make a reasonable effort to protect a child from abuse, neglect, or exploitation by another person. Generally, child neglect is classified as a third-degree felony in the state of Florida, punishable by up to 5 years in the Florida State Prison and a fine of up to $5,000. However, if the child suffered from great bodily harm, permanent disfigurement, or permanent disability, then the penalties can become more severe. In order for the state to prove the crime of child neglect, they must prove the following 3 elements beyond a reasonable doubt. 1. The defendant, willfully or by culpable negligence, neglected the victim. 2. At the time, the defendant was a caregiver for the victim. And 3. At the time, the victim was under the age of 18 years. Being accused of child neglect is an extremely serious allegation that can carry life-altering consequences. If you've been charged with child neglect in the Tampa Bay area, call Hunt Law at 813-787-4849 today for a free case consultation.